Can a judge remove a defendant from a courtroom without giving him warnings first? To find out, you have to read People versus Dunton, but it's 35 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Dunton. The citation for this case is 2024 New York Slip Opinion 02130, published by the New York Court of Appeals on April 23rd, 2024. The issue in this case is whether it's error for the court, for the judge, to remove a disruptive defendant from the courtroom during the rendition of the verdict, but before the jury has fully given the verdict and been polled. To appreciate the context of this case, what you should know is that under CPL, under Criminal Procedure Law 260.20, which talks about the defendant's presence during a jury trial, it states, this is the quote, this is the actual section, a defendant must be personally present during the trial of an indictment, provided, however, that a defendant who conducts himself in so disorderly and disruptive a manner that his trial cannot be carried on with him in the courtroom may be removed from the courtroom if, this is the important part, after he has been warned by the court that he will be removed if he continues such conduct, he continues to engage in such conduct. So the important part of 260.20 is that there's a warning involved. If you're going to remove a defendant, according to the statute, you have to warn them that if they continue being disruptive, they'll be removed. And if they then continue being disruptive, the judge can remove them. Other than that, they have to be present. And the other thing you have to know to appreciate the context of this case is what a writ of coram nobis is. It's a very old English writ, like this is like an appeal you might make. And it still exists in some states. In New York, it exists, but it's only for a criminal appeal for claims of ineffective assistance of appellate counsel. So if the claim is that your appellate lawyer, the lawyer who filed your appeal, was ineffective, you can then file a writ of coram nobis to complain about it. All right, what are the facts of this case? The facts are a little complicated, but basically the defendant here is Corey Dunton, and he goes to Bryant Park in Manhattan, and he basically tries to take a jacket from a 17-year-old. He's 16 years old, Mr. Dunton. And he goes to a 17-year-old and says, give me your jacket. And the 17-year-old says no. So the defendant, Mr. Dunton, takes out a gun and shoots the 17-year-old 4 times and also misses the 17-year-old, striking a bystander, a 14-year-old bystander, paralyzing him. So Mr. Dunton's arrested. He sits in Rikers Island Correctional Facility pending trial. And while he's in Rikers Island Correctional Facility, he is a poor prisoner. He gets in unprovoked fights. He got some random acts of violence. He punches corrections officers. He punches inmates. He throws chairs at officers. The trial judge is informed of this when the trial starts, and the defendant is classified as a security risk. So when the jury is finally brought in, the judge tells him he's not allowed to get up. He can only turn his head to acknowledge the prospective jurors. He can't turn his body towards them. And while he had several violent and disruptive outbursts outside of the courtroom, he's mostly okay inside the courtroom. But that even continued during the course of the trial. While he's being brought daily to the courthouse, he floods jail cells. He fights other inmates. He fights officers. He spits at an officer. He damages a computer. He was also late a couple times to court, so he appeared to be malingering to the judge. The judge warned him that if he continued delaying, if he tried to delay this court proceeding, the trial will be held in his absence. That's an important part of this too. And even during the trial, he started doing some things where he allegedly stared down witnesses. He put his hand over his mouth, allegedly maybe to intimidate witnesses, to have them not speak. And basically, at one point, the defense counsel asked the defendant to stand up and point to a chart, and the judge says, no, I'm not going to let him do that because it's a small courtroom and he'll be within 5 or 6 feet of the jury. I won't let him do that. So we're now towards the end of the trial. It's almost at the verdict. And right around the end of the trial, the defendant punched another corrections officer in the face and was sprayed with chemical agents. So the judge says, you know what, at this point, when the jury comes back to give a verdict, you're going to be handcuffed. Okay? So he's handcuffed during the jury verdict. The jury doesn't see it. But when the jury starts reading its verdict, there's 7 counts that they're deliberating. They find him guilty, 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 guilty. And at that point, the defendant starts laughing. And the judge says to the defense counsel, control your client. And they find him guilty again on the sixth count. They're still going through the verdict. And at that point, the defendant starts yelling at the jury, telling them, cursing at them, being mean to them, abusing them. And at that point, the judge says, take charge to the court officers, get him out of the courtroom. But the jury had not yet finished giving its verdict. The jury had not yet been polled for its verdict. So in his absence, the judge allowed the jury to finish their verdict. They found him guilty of the seventh. So they found him guilty of everything. And he polled the jury. And the judge then made a record of what happened, why he removed the defendant. After the conviction, an appeal was filed for the defendant, but the appeal did not raise the issue of the removal from the courtroom. A later appeal was filed under a writ of coram nobis, saying the first appellate lawyer was ineffective because he didn't raise this issue of removing him from the courtroom without proper warning. And that's what we have. Now it goes to the Appellate Division. They grant the writ. They reverse the conviction. It goes to the Court of Appeals on a people's appeal. And here we have the holding. The holding is, was the judge wrong to remove the defendant? The answer is no. Although the statute 260-20 says you must warn the defendant before you remove him, there's a court precedent. The court says only if it's practicable. Only if it's practicable. If it's impractical to warn the defendant, you don't have to wait for the defendant to punch someone to give him a warning. You can remove him anyway. So they say in this particular case, the court may dispense with the constitutional and statutory warnings when it's impracticable to give them. And in this case, based upon all the facts here, and that's why I laid out all those facts, based upon the defendant's repeated violent outbursts, the concerns the court had, the defendant's acts in court, it was impracticable to have to give the defendant a warning before you removed him. And in this case, it was okay. So they say it was not a violation of his constitutional rights, and therefore it was not a violation of ineffective assistance of counsel because the defendant, this was not a violation of his rights anyway. So they deny the writ of coram nobis. They also uphold the conviction, and that's the case of People versus Dunton. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.